to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti. Today, we have a very interesting program. On an earlier episode, we talked about why drug prices are as high as they are in the United States. We talked about market factors and regulatory factors and other issues. Today, we're going to ask the same question, but we're going to talk about Europe. And I think it's a very interesting contrast. There are different rules in place, but I think what you'll hear today from our guests is there's also a different approach to how we think about pricing and how prices can be regulated and impacted by various market factors. My co-host today is Matthew Hall. Hi, Matthew.
Hello, John. Good to be back.
Matthew, it's nice to be talking to you again. So, Matthew, what are we talking about today?
Well, as you said, John, there's been a previous version of the podcast looking at drug pricing and antitrust issues affecting that in the US. Drug pricing is, of course, a big issue in the EU too, and it raises a lot of public policy and regulatory issues in addition to antitrust or competition, as you mentioned. I think it's also fair to say that both at the EU level or the European Commission and at the member state level, so the national competition regulators, a key focus has been and continues to be on drug pricing. So it is a timely moment to look at these issues.
And Matthew, why is this important?
Well, as I said, and as you mentioned in relation to the previous podcast, it's a big public policy issue. There's obviously a huge level of spending on drugs as the population ages. So I think it's a good time to look at the state of play in the EU, contrast it with the position in the US, particularly on the antitrust side and also on the regulatory side, and look at some of the specific EU cases in the area. There's a lot going on at both the Commission and the member state level. So I think our guests will be very interesting to talk to today.
And who are our guests today?
We have Paul Csiszar. He's at the European Commission in Brussels, which is, as you will know, and most listeners will know, the EU Civil Service. He's the head of Directorate E within the Directorate General for Competition, usually known as DG Comp. Directorate E runs cases in antitrust, state aid, and mergers relating to basic industries, manufacturing, and agriculture, which includes pharmaceuticals and health services. We also have Bill Batchelor, who is an antitrust and competition law partner at the law firm Skadden Arps, based in Brussels and London. He has long experience of EU and UK competition law, focusing his practice on conduct investigations, abuse of dominance, cartels, and vertical agreements. He's also done a lot of work on merger control and litigation, as well as providing general counseling advice. So welcome, Paul. Paul, we'll start with you, please. If you could just give us a brief description of your role there at the European Commission, and also an outline of how pharmaceutical pricing in the EU generally works, because, of course, there's quite some differences with other jurisdictions around the world, and in particular, the US.
Right. Yes. Good afternoon, everybody. Happy to be here. I'm one of the directors of the 5 sectoral directorates of DG Competition. I oversee antitrust merger and state aid cases in many different industries, ranging from pharmaceutical, health sector to consumer goods, basic industries, manufacturing, and so forth. So we don't do energy, ITC, banking, and we don't do cartels. The rest comes to my way. I'm not a specialist in pharmaceuticals, but my colleagues have a lot of experience, and again, as you know, we do both, which we call antitrust and then the merger enforcement. Now, as to the regulatory regime in Europe, you may know that regulating reimbursement systems, marketing authorizations, pricing is member state competence. So we are not doing it at EC, European level, and each member state uses different schemes and policies tailored to their own needs and their own policy objectives. So this is very different. When it comes to competition law enforcement, it's a two-tier system. There's no hierarchy between them. We do it at EC level on the one hand, and also each member state has its own national competition authority with full competence to intervene in cases which would be roughly the equivalence of your Sherman Act Section 1 or Sherman Act Section 2, some unilateral conduct behavior. So you mentioned that it's not really a free market, heavily regulated. I would make a point here that it would be an oversimplification to conclude that pharmaceutical prices are regulated like, for example, utilities. There's a fundamental difference between, on the one hand, when you build a power plant or you build a bridge, and then you have to negotiate ex ante your revenue stream from your clients, be it the state or private users, on the one hand. Pharmaceutical companies don't invest in a particular member state, so although usually the reimbursement are set at national level, which you would call one price, the pharmaceutical company can always say, look, this is for this one, it's not worth for me to come in and sell my drug. This happens from time to time. For example, France has a regulation which sets a certain percentage for generic prices compared to the original price, the originator's price, and then often no generic comes in for that heavily discounted percentage. And then what happens? The regulator, although it's a price regulator, engages in a market activity, sends an RFQs to potential generics and says, at what price would you come and enter with your generic price? So there is a lot of traditional market forces which also takes place. Now, as you know, and I don't want to go into the details, there are many other regulations on member state levels, for example, encouraging doctors to prescribe the active ingredient, not a particular brand, to save costs. Also, there are pricing schemes which has reference prices to other member states' prices, or the so-called health technology assessment, which tries to assess society's added value of a particular drug, and irrespective of the marketing authorization, maybe the reimbursement is curtailed or not granted. Now, this is applicable across the board to off-patent, generic, debranded, patent-protected prescription drugs, OTC drugs as well. Perhaps I stop here, and then if you have a follow-up question or Bill has some comments, happy to jump in again.
Thank you for the introduction, Paul. I think it's fair to say it's a complex situation across the now 27 member states. Looking at it at a broad, high level, is there a concern, as there is in the US, about high drug prices in the EU? And in particular, what type of drugs is that concern being raised about, if it is, in fact, being raised?
Absolutely. There is a concern. I think in all advanced industrial societies, the quality of life, providing good health care generally to their citizens is a major concern. Both the previous commission, this commission, the European Council, heads of states, the European Parliament, all set a principle that we should work toward full access to innovative and affordable medicines to our citizens. I know in the U.S. this debate is a little bit more complex, whether healthcare is a product or a right. In Europe, as you know, pretty much everybody tilts toward what you might be familiar with, the Canadian system that we should provide across the board socialized medicine, including access to drugs. As you know, healthcare prices and particular pharmaceutical prices are quite high. So when it comes to the public and politicians, that affects all drug prices. I think in enforcement circles, one should make a distinction between off-patent generic drugs generally and proprietary drugs, because obviously we are worried, and I think policymakers everywhere should worry about sufficient incentives for the pharmaceutical industry to continue to do research and development, which is very costly and risky as well. So these factors can and should be weighed in all policy discussions.
As you say, there must be incentives for innovation. What looked at a high level before we move on to Bill for the private practice view, what types of pharma antitrust cases are we generally seeing in the EU at the moment? I know that there's been a lot of, for example, excessive pricing type cases recently, which aren't something which, as I understand it, appears in the US at all. But what kind of cases are we seeing at the moment?
Right. Excessive price cases are very interesting. Before I go there, I would just make a general comment that almost surprisingly, the alignment of EU and US antitrust enforcement generally are very, very similar, with very, very similar outcomes. That's true for merger control as well as what we call the antitrust cases as well. And I think by and large it's applicable to the pharmaceutical sector as well. I think on both sides of the Atlantic in the last 15 or so years, we've been trying to tackle pay-for-delay agreements. When it reached the U.S. Supreme Court and the activist decision came to light on your side of the pond, we had our first decisions, the Lundberg, the Servier cases coming out from the Commission. Those are on appeal, sometimes on their second appeal level, going before the highest court in Europe. So I think in the pay-for-delay era, it's been, I think, a very, very similar alignment. There are some nuances on what by-object offense means. Some of the technicians know these things. I don't want to get into it unless somebody's interested. But in by and large, in for pay-for-delay agreement, we have an alignment. Now, one area of the unilateral conduct case area where we have a basic difference in our basic statutes, which is the treaty provision, Article 102, the unilateral conduct provision, which roughly the concept set out in Section 2 of the Sherman Act, is that you can have a possible abuse of a dominant position, an unlawful conduct, merely by charging unfair or excessive prices. So the legislator expressly provided in the treaty provision this possibility, which of course, as you know, not only is absent in the Sherman Act Section 2, but also absent in pretty much in the case law, that a pure exploitative abuse merely charging high prices should not constitute an antitrust violation. That's not the case in Europe. So the question is not whether antitrust should address possible unfair excessive prices cases. It's more like when, under what circumstances intervention would be warranted. Before everybody gets excited, the bulk of the last 20, 30, 40 years of unilateral conduct enforcement in Europe was based on alleged possible exclusionary conduct leading to foreclosures, as opposed to purely exploitative ones. So these cases are very rare. Case law is very rare. Leading case goes back to 1972. Bill may want to comment. Recently, in the fall, we saw more cases at national level as well. We in the Commission, we have a pending case against Aspen, which relies on this particular treaty provision. But I must say there are many challenges generally on qualifying what should be an excessive price in these cases, because of course a broad interpretation of that concept could lead to a very, very wide floodgate of cases coming in all sectors, because quite frankly, customers always consider prices too high and too excessive, and sometimes you have many good products, be it pharmaceutical or otherwise, with high margins. So we have to be careful.
We'll give you a little quiz. We'll give you a little quiz in a moment on what the test for excessive pricing is in the EU. So we'll give you a little chance to prepare for that. But I'd like to move on to Bill. Paul mentioned the Aspen case, which I think the European Commission has described in a UK court as a very significant case for it on excessive pricing in off-patent pharma. But Bill, we were talking, Paul and I, in the introduction about the public policy angle of these cases. Could you give us a view from the private practice side on these excessive pricing cases and how they look like to you from that point of view?
Yeah, thanks so much, Matthew. Paul, great to be here. Thanks so much for the invitation. Should preface my remarks by saying that nothing I'm about to say represents necessarily Skadden's view or any client it represents. To echo Paul, behind those deceptively simple words, a monopoly shall not charge an unfair price, you find extraordinarily difficult cases. And so much so, you see statements on enforcement policy by some authorities that they will not second guess the value of an innovative pharmaceutical drug. Look here, for example, at the UK's OECD submission in 2011. Some might say that's for very good reasons. A high price signal encourages innovation, encourages entry. Go and chase those areas of unmet need. That's where the public purse will reward innovation. You have specialist authorities dedicated to working out what the value add of drugs are. Dossiers with thousands of technical annexes and data dating back years looking at comparative therapeutic advantage. All that goes into judging what an appropriate price might be. So a threshold question for many practitioners is this really a gap that antitrust needs to fill? Specialist pricing authorities, powers to regulate prices where governments or health systems feel that they're not appropriate. Should antitrust be playing a role here at all? We've seen this very recently in the Competition Appeal Tribunal case in Pfizer-Flynn. So there, the tribunal reverses a finding of the UK authority that there was an excessive price charged for phenytoin, an anti-epilepsy drug. I think it's really interesting. You see the tribunal at para 412 with faintly concealed astonishment reacting to the statement by the UK authority that this drug has no value. Remember, the test that the CMA is trying to hit is to show that a drug, the price offered for a drug, was far in excess of the value of that medicine. And the CAT says we find that outright rejection that a drug has any value to patients is surprising. Yes, this was a drug that was old, but the CAT says that's not relevant. Old medicines can be extremely valuable to the patients that use them. Yes, it has a narrow therapeutic index, but for patients who are stabilized on this anti-epilepsy drug, that's valuable, surely. So to make value judgments, patients that use them, the CAT, you can see, being very troubled to hear statements from authorities that little or no value might be ascribed to them. So I think that gives you a flavor of just some of the public policy issues that you can see in the cases that have been taken so far and in the reaction from the appellate courts to the cases that have been decided.
Perhaps if I comments on Bill's points. Is that okay?
Of course. Please go ahead, Paul.
Yeah. Thanks. Well, Bill was just posing a very valid question. Is there a gap here? Should antitrust come in and try to fix something which pretty much we agree that there is a problem? When I get these questions elsewhere, I always like to use a U.S. example because that's not a European case, so it's not pending. I can comment freely, or a lack of case maybe until very recently is Mr. Shkreli's Daraprim case, which you remember, a life-saving drug, which expired, the patent expired in 1963, was sold in the last 50 years for a few bucks, and then his company raised the price by 5,000% to $750, and 3-4 years after he'd made it, this price increase in 2015, the price is still there. So clearly, we have a market/regulatory failure to some extent, because, by the way, the same Daraprim is sold 70 or 90 other countries around the world, because originally it was made for tropical diseases. Today is part of a life-saving cocktail, and in other countries, the drugs, a pill is sold less than $1. So. Still, society, be it private insurers, private buckets, or the government, has to pay $750 for that drug. Again, patent expired 1963. Clearly, there is a problem. Now, one can speculate that regulation should fix this problem, but if the cavalry doesn't come over the hill, what do you say? I have a statute, which I just mentioned, the treaty provision, which says excessive price can be an offense under our regime. So I don't really have to define what is excessive. It's a little bit like I know it when I see it test, and I think Mr. Shkreli's case, hypothetical case, really fits the description. Right? Because there's absolutely no change in the manufacturing process. There was no change in the cost of inputs or ingredients. It's whether it's valuable for society or not. Obviously, those who wanted to live had to cough up, or the insurance company, the $750 per pill. So I think one should appreciate, at least in Europe, that if you have a provision and you face, and we're talking about drugs here, not other consumer goods, one should seriously consider as a second best, perhaps, taking some of these cases and through general deterrence, perhaps deterring other generic pharmaceutical drug companies to engage in this type of conduct.
Indeed, Paul, and I think as you say, there are two sides to the coin. I just wanted to come back to the test that I mentioned I was going to give you, or Bill, if you prefer to answer this, but we've been skirting around the fact that excessive pricing is actually in Article 102 of the treaty, in effect. We've been skirting around how the test is defined and arguments in the UK courts about what that test should be. But can we just look back to the old case law and just very briefly set out what the test has been explained back from those old cases? Paul or Bill, if you prefer to.
Sure. Yeah. No. Happy to. Just, I think your audience, if you're interested, people definitely have to look up this 1972 ECJ case, United Brands. Basically, the court held you have to use a two-pronged test, and I'm going to give you pretty much the language of the test. The question is to determine whether the difference between the cost actually incurred and the price actually charged is excessive. So that's the first leg of the test. And if so, whether a price which has been imposed is either unfair in itself or unfair when it's compared to competing products. Now, this sounds a good test, but I think this is a field trip for lawyers and economists and experts and advisors and academics.
As you say,
obviously, you end up very fast in the gray zone. Again, that's why I like to go back to Mr. Shkreli's hypothetical, because I think one could reasonably conclude that this test is met in the Shkreli case. Now, if you have not a 5,000% price increase, but you have a proprietary drug, for example, where how do you count for the innovation and the failed innovation by the same drug company and so forth, things can get very complex. What I would say, and I would jump 30, 40, 50 years ahead, that in a recent ECJ decision, the court said there could be other ways to establish unfair pricing. So it left the door open depending upon which sector we are, depending on the specific circumstances of each case, what is the history of the drug, and so forth, left it open to have the prosecution, the agency, to come with a reasonable test. It did warn, however, that you shouldn't cherry pick your test, because whichever test you bring, competition agency, the test should be selected, quote, in accordance with objective, appropriate, and verifiable criteria made and applied on a consistent basis. So
that's probably
again, it's not cherry. I'm sorry.
That's probably a perfect segue to get back to Bill, because you're mentioning there other types of tests. And also, I think it's interesting to pick up the point that you're commenting about on that old US case where the increase in price seemed to be incredibly obviously excessive. So, Bill, thinking on those points and kind of the practical side of arguing and winning these cases or defending these cases in court or before a regulator, what kind of tips or arguments or kind of learning do we have from those cases?
Yeah, so I think the essential counterpoint to Paul's examples again comes from the UK. So we have phenytoin, this same anti-epilepsy drug. Patents no longer apply. It was discovered and launched in the 1930s. It remains an important third-line treatment, but for a declining number of patients. Most have moved on to more modern anti-epilepsy drugs. So Pfizer, the manufacturer, has a problem. At 8 pence a pill, in the context of slowly declining demand as patients move on to other drugs, this medicine isn't commercially viable for them. There's another pill on the market made by Teva. It's exactly the same molecule. So phenytoin, chemically identical, but rather than capsule form, it's in tablet form, so a different presentation. Now, Teva's pills are on the market at £100 a pack. The Department of Health in the UK, the one with all the powers to determine what it thinks is a fair price, they protest. They say, Teva, this is not right. Teva drops the price then to £30 a pack. The Department of Health ostensibly, and I say this because it's important, ostensibly seems satisfied. That's the price that gets paid for Teva's pill. So now imagine you're Pfizer. You have a low value, commercially perhaps no longer viable drug, or at least perhaps not so in the short term. Where's a fair place to try and put your prices to? So bear in mind that you're looking at a United Brands test. You're saying excessive price. Would you feel safe putting it, say, halfway to Teva's price, the exact same molecule but different presentation? Remember, are you excessive compared to cost? That's United Brands. And if so, are you unfair as a price or with reference to comparators? Surely if you were Pfizer, putting your price up to a place that was lowest than your nearest rival for exactly the same pill. So far, we might feel if we were advising Pfizer, well, that sounds like a reasonable place to be. Yes, it's a substantial price rise, but it doesn't sound like an excessive and unfair price. Remember, the Department of Health is paying for Teva's drug, that exact same molecule. Not so, the CMA finds. This is an excessive and unfair price. That's worth £84 million in a penalty. A fair price, by comparison, would be a 6% return on sales. That was fair for a generic product. Now, that's worth pausing there to say, wow, okay, 6%, that's what that. Compare the Italian authority that said 8% was fair. Now, which is right? Is it the UK or the Italians, or is it all a bit arbitrary? Well, the Court of Appeal Tribunal, the Competition Appeal Tribunal on this says, yes, that is a bit arbitrary. You should be looking at comparators, Teva's pill. So what does the CMA say about Teva's pricing? That seemed to be accepted by the Department of Health. Says the CMA, you should have known that actually Teva's price was excessive too. And the reason you should have known is because the Department of Health also complained about Teva, but the CMA declined to investigate because it was not within their administrative priorities. You might share with me and the Competition Appeal Tribunal's incredulity on learning of this fact. And indeed, at one point, Pfizer should have contacted Teva about its pricing, or the Department of Health about Teva's pricing. Then they would have known what was a fair comparator. And the CAT at 380 expresses the view that a competition authority suggesting that one competitor contact another about pricing. Ended. So these are extremely tricky cases. And the CAT makes the crucial finding further at 438, just because a price is increased doesn't trigger a finding of excess. You need to think through all the reasons why that increase might have occurred, and excess alone might not be the case. You might, for a non-viable product for which you're expending significant cost against a declining market demand. So I think the phenytoin case is a keen learning study of all the complexity that can occur in these cases and the difficulty of the regulatory and price assessment authority interface.
I think that's without doubt, and that's probably why the European Commission was very keen to intervene in that case before the Court of Appeal and is taking a close eye, as I understand it. Now, we could talk about these things all day. We haven't had a chance to get onto some other interesting issues. There are some discount and rebate cases going on in the pharma sector in the EU at the moment. We're probably going to have to wait for another day to talk about those. John, I think, unless you tell me otherwise.
Well, yes, indeed. And Paul, maybe if I could just come back to you and ask you a couple of follow-up questions. You've been working at the Commission for some time now. Do you have a sense what's different about working in the Commission as a civil servant as opposed to working, say, as a staff lawyer in the United States?
Wow. When you're in public service, I think, and I was in the UN for a couple of years after private practice before I joined here. You have the luxury of not having one particular client's interest towering over your shoulder, so to speak. So, and that's a great luxury. That I think you have more professional freedom to shape what you want to do, and and you would like to think that you add some value overall to society. And that's like when people have a nice voice and they make people happy when they sing or whatever. You do something good for no particular return. You get your salary, and still there is a benefit out there. I mean, I'm very passionate about pharma as a whole, because society's resources are finite everywhere in the world, and every time when there is a drug which goes for $750, which could be sold for $750, somewhere somebody gets a shorter bed, a shorter visit from the doctor, because we have finite resources. So I think, I hope I answered my question. It's fun to work in the public service.
And Paul, tell us something different or unusual about yourself that we wouldn't know about if we just knew you professionally.
I like voice. I don't play the piano. So the only thing which I can give, not just to my family members, but some friends and people in my department, sometimes I cook for them. I'm an amateur, not a great cook. Hopefully, I would like to think better than the average amateur, and that's about it.
All right, well, let's go to our last segment that we call The Curious Hat.
And now it's time for The Curious Hat!
So in the studio here in Washington, D.C., I have an actual hat that has actual questions in it. Since you cannot pull it out, Paul, I'll ask you to pick a number between 1 and 15.
15.
All right, number 15. Paul, if you couldn't live in the country where you live now, what country would you like to live in?
Wow, that's I split my time between California and south of France and Italy. Sorry, 3 countries. I couldn't give you one.
Living in the south of France can't be too terrible. Any other country that you would really like to visit?
Japan. I've been there before. I'm planning another trip. Asian cultures, Asian food as well. So I visit California regularly. I have family ties there. Yep, I think Asia is a good place to be. Maybe not the very same day in these days, but because of some epidemic threats. But otherwise, I think it's a good place to be.
Bill and Paul, thank you for being on the program. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.